Friday, the 26th of January 2007, 8:09 a.m. Councilwoman Bell is present. Councilman Hodge, Vice Mayor Losner, Councilman Porter. This is a resolution of the City Council of the City of Homestead, Florida, approving consent agreement between the Miami-Dade County Department of Environmental Resource Management, Durham, and the City of Homestead concerning the excavation at City Lake, provided for implementation, provided for effective date. Is there a motion?
I'll move it, Mayor.
Moved by Councilman Porter, second by Councilman Hodge. Any comments?
Yes, Mayor.
Mr. Vice Mayor.
Thank you. Kurt, I recognize this is a long way from the first discussions with Durham, and this is the best deal we're going to get with Durham, and something that in that regard should go forward. But again, I want to be sure that the practical effect of this is that the operation can be reopened for removal of the fill that's now owned by Shores. Was that?
Well, this is one of probably three issues. Well, really two now, because the core has been resolved for now. So this is 2/3 of it to get done.
Well, I realize there may be other agencies we need to deal with.
Yes, then this will be.
But the end result would be simply that Shores has the right to go in or have its operator go in and remove whatever fill it is entitled to receive.
Correct, and we're going to have to probably put in some kind of mechanism to oversee that operation, so we don't have what occurred before again. So we probably would be wise to do that, even with Shores coming in or anybody else going in there.
And the time sensitivity here is that the 1-year permit extension that's contemplated has been running since early this month.
I just want to add that this was after, and then for the record, after a lot of negotiation. We didn't start at this point. We started much higher and much more severe against the city. So that's why it's taken this time to get this done. It's been a lot of back and forth.
Right. Okay. Well, I have an additional comment. I know the attorney wants to jump in.
Okay. No, my comment is just that I know all of you understand that there are severe consequences that are set forth in this consent agreement. I mean, this has been negotiated for months, and it's easy to go by and say, well, why are we paying so much? Why is it so severe if we violate it and all? But this is really, most of the negotiations we sat in on, many of them we didn't. But from a legal standpoint, I just want to really make a couple points. One is that you understand that if there's a violation, it's very severe. The second thing I want to make you aware of is we are still attempting to get some additional protections from the city. For example, if there's a violation here, it says the permit's revoked without appeal. We would like to at least have notice and an opportunity to be heard. There's another section in it that says that we are permitted to come back and to excavate non-excavated areas. We would like it to say simply that we can come back and excavate areas that have not been excavated to 52.5 feet, because even though I'm beginning to understand the mechanics of excavating because of some pending litigation that we have, there is a possibility that we can come in and excavate areas that have been excavated to 20 feet. So it doesn't say that right now. We don't think that's a problem, or we're hoping it isn't, but we still want to try to get that in. So what your resolution says is it uses language substantially in the form of the consent agreement. So if we change it, we might change it, but we were telling you that anything we change are going to make it more favorable to the city. And so that's really why the language of the resolution says substantially in these terms. We still hope to get some additional protections.
Good.
Question, Mayor. Oh, sorry. He's not finished.
Well, I just want to get my observation is I think we're really kind of in a catch-22 situation here. We need to do this. We need to settle up with the agencies, but my concern is the metaphor I've been using lately is it's kind of putting all of this to rest, kind of like building a space shuttle. There's a million moving parts, and this isn't ready to fly yet. I think this agreement's a good fuselage, but we don't have the rings on it yet. We've got shores on one side and litigation on the other. And I hope that by approving this, we're not signing a blank check that's open-ended that the taxpayers are going to have to, even though we're doing this in effect and Shores is going to be the beneficiary of this, we don't know what claims are still out there. We don't have any estoppel from Shores that their damages won't be pursued against us, if any, for the closure of the pit. Is that
Well,
accurate?
we believe that under the agreement with Shores that we do not have liability to Shores. I think it's quite clear that their agreement is with Mr. Munns and not with us, and they may make claims against us, but Mr. Lazo, you're right. I mean, it's out there. Although we think we're okay, it's out there, and there is substantial pending litigation. So a lot of these issues are still up in the air.
Thank you. That's all, Mayor. Thank you.
Thank you. Councilman Bell?
Thank you. And this agreement with Durham is basically has a sunset of 1 year? Is it a 1-year agreement or is it ongoing?
This is well in perpetuity until, I'm sure, the pit.
I'm sorry, as far as the permit.
Oh, as a permit, I'm sorry. This, really, not with Durham, but with the engineers is where we've got the timeline till January 5th, 2008. Right now, if this works with Durham and it works with South Florida, we don't believe that, until we finish. We had a 5-year, I think. I don't remember what date that ended, but...
Mr. Mayor, council members, the reinstatement of the permit will be for the expiration of the original permit. I think it's 2008, I'm sorry, like I said, 2011 or something. We'll get you the date, but it will go back to the original permit.
So and I agree. I think, Mr. Sorter, that we should explore all avenues about being able to excavate our fill, or have of course hire somebody to come in and do it, because there's a lot of money that's sitting in the ground that really belongs to the taxpayers of Homestead. Especially maybe we can recoup some substantial portion of losses that we've now taken, the major hit that we've taken on behalf of the actions. So I think that would be good to be able to recoup some of the losses for the taxpayers of Homestead. This has been quite egregious. So, it's been well over 1 year since we even had the cease and desist order from Durham. I think that was back in November of 05. So it's been a long time. Thank you, Mayor.
Mayor, I want to clarify, though, for the record, since we've been so sensitive to clarifying the record lately. This agreement in no way makes any determination as to who has rights to ownership and excavation of any fill above and beyond Shores. Okay.
But the assumption is, according to our contracts, that we assert that we know that we have the right to that fill.
Well, I think that's...
Of course, that's in litigation,
yeah,
right? So I'm proceeding as if I know. I read the contract. I know what it says. I'm fully aware of what it says, and I'm proceeding as if what I read is actually what I read. Thank you.
Thank you.
Any other comments? Any other comments? Mr. Munns?
Good morning. Pinky Munns, President of Redland Company. Just a couple little things. Just wanted everybody to realize that Redland didn't participate in any of the negotiations or drafting of that consent agreement, and were completely excluded from any of those entire processes. And by the terms of our contract, we had a right to cure any default, and we wanted to be part of that cure process, but we were never allowed to participate, even though we set up the original term meeting, and actually over a year ago. Even though we didn't participate, we would have agreed to all reasonable remediation requirements, which this agreement appears to contain. However, we think the fine seems excessive and unfair, no matter who's paying it. We'd like to see some breakdown of that, and no explanation was ever provided by the city or Durham on how they came up with that $340-some thousand. I don't know if that's something that you all know the breakdown. The only other thing is, if the city was to reinstate our contract, we would agree to pay any and all those fines associated with that, just for everybody's information. That's all I got, Mayor.
Thank you, sir.
And complete the remainder of the contract.
Thank you. Mr. Schroeder?
Mr. Mayor, just to respond to Mr. Munns, first of all, they were excluded because they've been terminated, and they have no rights under the contract. That's our position. Of course, it's up to a judge or ultimately a jury to decide that. Second of all, as you know, we have pending litigation with Mr. Munns, so I would just caution you, to the extent that anybody wants to make any comments, I would suggest that we don't make any comments.
Thank you, sir. Any other final comments? Roll call, Madam Clerk.
Vice Mayor Losner?
No.
Councilman Hodge?
Yes.
Councilman Porter?
Yes.
Councilwoman Bell?
Yes.
Mayor Warren?
Yes.
Motion carries.
The special call meeting is adjourned. Thank you all very much.
Is that the guy? Is that the 2-year-old and me? Is that him? The young guy? I don't know. I never see him.